Hello, my name is Barry Arrington. I'm the Chief Legal Counsel of the National Association for Gun Rights. And today I'm going to talk to you about something in Colorado that the Supreme Court of Colorado says is available to pornographers and criminals, but not law-abiding citizens trying to exercise their right to keep and bear arms. Stay tuned, and we'll talk about that. And even if you don't live in Colorado, something that should be interesting to you because it is consistent with kind of the ad hoc nature of make it up as you go legal precedent that we see courts around the country when they're dealing with the Second Amendment issue. So, where did we start? In 2013, the Colorado legislature passed a ban on firearms magazines, and the National Association for Gun Rights and the Rocky Mountain gun owners immediately filed lawsuits seeking to enjoin it. And here's an interesting take on this. We did not file under the Second Amendment in federal court. Instead, we filed under the Colorado Constitution, the state constitution, in state court. Well, why did we do that? And the answer is pretty simple. Because the Colorado Supreme Court, over the years, had said, we've got a special deal for you if you want to bring a case under the state constitution. If you meet two criteria, we will say that the state constitution protects your rights even more than the federal constitution. Well, what are those two criteria? Pretty simple. If the text of the state constitution is broader, in other words, it textually, on its face, protects a right that is greater and more robust than the federal constitution, step one is met. And if under the history and tradition of the people of Colorado, since they enacted their state constitution in 1876, would suggest that Colorado citizens value this to an even greater extent than the citizens of the United States generally over their history, then step two's met. And so we thought, wow, Article 2, Section 13, Colorado Constitution, way broader than the Second Amendment. And so we thought the text step is clearly met. Then we started looking at the history and tradition of the people of Colorado. Turns out our expert at trial, and even the government's expert at trial, agreed that the state of Colorado's legislature had never, not even once, passed a law banning possession of any firearm or firearm component from 1876 all the way up to 2013 when they passed this firearms magazine ban. This was the very first ban of any sort of firearm or component in the history of the state of Colorado. We said, well, wow, our history and tradition step is met. So people might ask, well, what about machine guns? Are you saying that Colorado doesn't ban machine guns? Well, interestingly enough, machine guns are not actually banned in the United States. Under the National Firearms Act, machine guns are licensed, heavily regulated, taxed, but you can go out and buy a machine gun if you get the proper licenses. And a lot of states will tag on to the national regulation and the national law, and that's what Colorado does. It says if you have a license under the National Firearms Act, then you have automatically the right to keep it in Colorado as well. And so we went to the state court and we said, look, we've got this test that the Colorado Supreme Court has announced. And we obviously comply with it under Article 2, Section 13, the Colorado analog to the Second Amendment. And the district court says, yeah, no, you don't. And we said, well, okay, we'll take it up to the intermediate appellate court, which is Colorado Court of Appeals, and the Colorado Court of Appeals says, yeah, no, you don't. And we said, well, surely when we get to the Supreme Court, they will say, well, what? Look, here's our test. You guys have not applied it properly. They clearly meet it. And so we said to the Colorado Supreme Court, look, you've case after case after case. You've said to pornographers, the Colorado analog to the First Amendment protects pornography greater than even the First Amendment. And you've said to people under criminal searches that the Colorado analog to the Fourth Amendment protects the right to, again, to not have unreasonable searches and seizures, even more than the federal Fourth Amendment. And so here, and you said, here are the two steps that we have to take: text, history, and tradition. We clearly meet it. Therefore, we should win this case. And the Colorado Supreme Court says, oh, you silly people. That's for criminals. That's for pornographers. There's actually a third step that it's kind of an unwritten step, but you should have known. And what is that third step? Well, it has to be a right that's favored by liberals. And your right is not favored by liberals. So, yeah, maybe you meet the two written steps, but you've clearly failed the unwritten step of trying to advance a right for law-abiding citizens trying to exercise their right to keep and bear arms. You're not a criminal. You're not a pornographer. You don't qualify. And so we lost. We litigated this issue for a number of years in the Colorado state court system, ultimately to lose. And in the meantime, there had been a federal challenge to the state magazine ban that had failed on standing grounds, and that was over. And so we thought, well, that's done. We're done in Colorado on challenging this magazine ban. That was until June of 2022, when earth-shattering news, that you guys have already heard about, Bruen came along and really changed the landscape for challenges to regulations and statutes banning firearms and firearm components. And so we filed a new case. And in the district court, we're saying, look, Bruen also has two steps. What are those two steps? Text, history, and tradition. Wait a minute, that's the same one that we had in the Colorado State Court, at least we thought. And it exactly is. Is it covered by the text? Is it covered by the history and tradition of the people of the United States? But under Bruen, there's not going to be this unwritten third step. How do we know? Because this United States Supreme Court has already held that common sense application of the history and tradition and text is going to prevail, and is not limited to just rights favored by liberals. So we say to the Colorado Federal District Court, again, we went to the federal court this time because the state court is hopeless. It's as if the Colorado Supreme Court took the analog to the Second Amendment in the Colorado Constitution, took an X-Acto knife and just carved it out. And it's no longer even there for practical purposes. So we went to federal court this time to bring our Bruen test. And we said, look, magazines are integral to the operation of semi-automatic firearms. Semi-automatic firearms are protected by the plain text of the Second Amendment. After all, it's the right to keep and bear arms. Firearms are certainly arms. So we prevail under the text step. What about the history and tradition? History and tradition is also taken care of because in Heller, 2008 decision, the court said that if you have an arm that's in common use, there is no history and tradition of banning arms that are in common use by law-abiding citizens for lawful purposes, and therefore we win on that step as well. And that's where the case is now. It's up in the Colorado Federal District Court. It's reached the summary judgment stage. We have a little bit more briefing to do in that case, but we expect to prevail ultimately in that case. Unlike the Colorado Supreme Court, we do think that the United States Supreme Court will take this right to keep and bear arms seriously and not limit the protection of rights to just those rights that are favored by liberals. So thank you very much for tuning in today. And as updates occur and we get more information about how this case is going, we will certainly keep you apprised.